Bismillah ar-Rahman ar-Rahim. Assalamu alaikum wa rahmatullahi wa barakatuhu. Welcome to another session of this course on Islamic inheritance law, in which we shall be looking at the inheritance share of the true grandfather according to the Ḥanafī Fiqh. Let's start off with text from the Sirajiyah. قال أبو بكر الصديق رضي الله تعالى عنه ومن تابعه من الصحابة بنو الأعيان وبنو العلات لا يرثون مع الجد، وهذا قول أبي حنيفة وبه يفتى. وقال زيد بن ثابت رضي الله تعالى عنه يرثون مع الجد، وهو قولهما رحمهما الله تعالى. وقول مالك والشافعي رحمهما الله تعالى. والجد الصحيح كالأب إلا في 4 مسائل، وسنذكرها في مواضعها إن شاء الله تعالى. ويسقط الجد بالأب لأن الأذى أصل في قرابة الجد إلى الميت، والجد الصحيح هو الذي لا تدخل في نسبته إلى الميت A true grandfather, a jaddu sahih, is a male ancestor between whom and the deceased no female intervenes. In other words, it is the father's father and his father above him, and so on. As long as the lineage runs purely through males, he is considered a true grandfather in Islamic law. There is a well-known difference of opinion among the Muslim jurists regarding the share of the true grandfather when he inherits with collaterals, that is, full siblings or consanguine siblings of the deceased. The difference arose because the jurists differed over a fundamental question: who is closer to the deceased, the true grandfather or the agnatic siblings? Should the true grandfather to be treated like the father, thereby excluding all the siblings entirely, or are the agnatic brothers considered closer in a different sense, such that they share or compete with him in inheritance? Because of this underlying disagreement about proximity and legal status, the scholars reached different conclusions regarding how the estate should be divided in such cases. From the perspective of the Ḥanafī Fiqh, the ruling concerning the true grandfather, al-Jad al-Sahih, is clear and relatively straightforward. In the Ḥanafī school, the true grandfather as a residuary excludes the full brothers and consanguine brothers. In other words, when the paternal grandfather is present, the siblings do not inherit at all. This was the opinion of Hadrat Abu Bakr, Hadrat Abdullah bin Abbas, Imam Abu Hanifa, Imam Ibn Taymiyyah, and many others. The true grandfather totally excludes the full and consanguine siblings. So, the Ḥanafī jurists explain that the true grandfather inherits like the father, with 4 notable exceptions. First, in the scenario where the only heirs are the spouse, the mother, and the true grandfather. In this case, the calculation differs from the case where the father is present. These cases were discussed when we looked at the inheritance share of the mother. Second, the paternal grandmother, meaning the father's mother, is excluded by the father according to all Sunni schools except the Hanbali school. This marks a difference between the legal effect of the father and that of the paternal grandfather. Third, the father completely excludes the full and consanguine brothers according to the Ḥanafī Fiqh, but according to the Maliki, Shafi'i, and Hanbali schools, the true grandfather does not exclude the agnatic siblings. We shall look at how the true grandfather inherits under the Maliki, Shafi'i, and Hanbali schools in a separate session. Fourth, in the issue of wala, the inheritance connected to manumission, the father of a manumitter may inherit alongside the son of the manumitter from the estate of a freed slave. However, the true grandfather of the manumitter is excluded by the son of the manumitter. This was the position of Imam Abu Yusuf, rahimahullah. This brings us to the end of this session. Insha'Allah, see you in the next one.